Hello, everyone, and welcome to the Employment Law Counselor Podcast. I'm your host, Jeff Stewart, and we're glad you found us. Our goal here at the Employment Law Counselor Podcast is to give you insight into the practical application of the world of employment law from the view of two seasoned attorneys. Each episode, we focus on one specific employment law, give you a little bit of history, how it's relevant in today's workplace, and some tips to ensure that you and your company stay in compliance with the law. While our podcast is not legal advice, it is a practical discussion between two attorneys that deal with the maze and minefield of labor and employment laws on a daily basis. If you like what you hear, please give us a 5-star review and subscribe so you never miss an episode. Today, we'll be covering an employer's obligations under OSHA. I'm thrilled to be joined by John Baker, who practices with me at White & Williams out of our Lehigh Valley, Pennsylvania office. How are you doing today, John?
I'm fine. How about you, Jeff?
I'm doing well. I'm glad you're here with me for our discussion on OSHA. Should we dive in?
Head first. Go ahead.
All right. Well, I'd like to give a general overview. And the law that created OSHA was passed in 1970. And the actual OSHA administration, or the agency, was created in 1971. So it just celebrated a 50th birthday last year. Did you give him a card or send him a present, John?
You know, I wasn't reminded about this, so I neglected to do that.
Maybe for their 55th birthday, you should send a card. So I'll try and remind you for that in a few years.
Please.
So why don't you tell our listeners what kind of the general purpose of OSHA is?
Well, OSHA is the Occupational Safety and Health Act. And the idea behind OSHA is to not necessarily guarantee, but to enhance the prospects of health and safety protection for employees in the workplace. And they do that in a number of ways. Certainly the ways that most employers are aware is through citations, fines, and penalties. It also has an outreach program. They're very big on education. They're very big on training and compliance as well. So a lot of people think of OSHA as just an organization that comes in and puts the hammer down, but there are aspects to it that can actually enhance the employer's safety and health prospects.
Yeah, I know a number of my clients refer to OSHA as kind of a gotcha organization. You know, if they come in, they're going to find something and, you know, they're going to issue fines, and it's like a quick gotcha, as opposed to necessarily being proactive on things. I think one of the other areas that OSHA really developed when it came into being was to provide an avenue for employees to raise concerns and to do that without the fear of retaliation, because there is a specific anti-retaliation provision in the OSHA law.
Yeah, you're right. The retaliation provision, for those that are keeping score, Section 11C, it's not unlike, you know, your Title VII, your ADA, those types of issues that have a retaliation aspect to it. If an employee who either makes a complaint or takes part in the process of a complaint, if the employee suffers an adverse consequence as a result of making that complaint, the employee has the right to sue the employer, in which OSHA would take the lead on that lawsuit for retaliating against the employee. Interestingly, one of the key issues that we're seeing in other Department of Labor venues is the misclassification of employees. OSHA is very concerned about that misclassification as well, because if a worker is not an employee, then they don't have the right to the anti-retaliation provisions.
Yeah, and that is not just for the person who makes a complaint, but for people who cooperate in an OSHA investigation. They also have that protection. So that's an important aspect as well. I get asked all the time, you know, in the world of employment law, not every law applies to every employer. The FMLA, for example, only applies if you have 50 or more employees within a 75-mile radius. There are size requirements for the ADA and for other laws. But OSHA is a little bit unique. It has no size requirement. It applies to essentially all employers with a very, very limited exception. That exception is where there's another federal agency that covers, such as, miners are covered by the Mine Safety and Health Administration. But for the most part, OSHA covers everyone. And when you think about it, that makes sense. I mean, we want all workplaces to be safe, regardless of their size. So, that's one where I think most people would agree it makes sense that OSHA would apply to everyone.
Yeah, it would be a tough position to take for an employer to say, look, health and safety overrated. So regardless of the size of the employer, they have to adhere to the general duty clause and the standards that are required.
So now that we know a little bit of the history of OSHA and its jurisdiction, which is basically everyone, let's talk about an employer's duties and responsibilities under OSHA. I mean, the biggest one is to prevent workplace hazards. I mean, that's a pretty broad statement. When you hear that, John, how do you communicate that responsibility to your clients?
Well, often the type of communication or the message that it needs to be sent depends on what the employer does. If it's in a manufacturing facility, there's one set of warnings. And if it's a small business without manufacturing, even if it's office or clerical, it's a different type. Let me just give you an example. I had in a manufacturing facility, it was a fatality case, and there was a 20-ton piece of machinery that fell on someone. So what you communicate to that particular employer or those types of employers is the necessity for a lockout tagout system. A lockout tagout is a system whereby you have two employees, one employee that is underneath the equipment, but that employee operate the on and off switch. It has to be done by someone else. So that's the type of message that's given to one particular employer, but I wouldn't give the same message about lockout tagout to for example, a small medical office.
Right, because they're facing completely different issues on a daily basis. Whereas the medical office may have to have specific responsibilities with regard to dealing with medical waste and how they're going to handle those things, which is an OSHA area.
And absolutely. And now bringing it down a few levels, there are standards under OSHA that really will apply to just about everybody. But as you get more specific, and that's what I find interesting about OSHA is it gets specific into the type of industry it is. Unlike Title VII, there's different standards that apply to different types of industries. So that's what I find so compelling about it.
Yeah. And I guess let's shift gears a little bit. One of the main ways that OSHA, I'll say, keeps tabs on employers or understands what it is that the issues are is that they have certain reporting requirements and reporting requirements that are triggered when there is an injury or something to that effect in the workplace. So let's talk about what kind of records have to be kept under OSHA. I mean, certainly they have to keep records of any injuries, but how do you advise your clients as to how they know when they need to report something to OSHA?
Typically, when I'm talking with a client, there is someone in office of the client that has a responsibility for OSHA. Sometimes it's an HR professional. If it's a big enough operation, they have someone that is their health and safety officer. Okay. So the first thing is to find the right person to communicate with.
And I would say it is best to have one point of contact for the company when they're dealing with OSHA. You should have someone designated before you ever have an incident. You should have one person, and I agree. If you have a safety officer or something like that, who one of their main responsibilities is to stay abreast of all changes and reporting requirements and duties, that's obviously ideal. Many times it gets left to the HR person if it is a smaller employer or someone who doesn't regularly deal with, I'll say, OSHA regulations, et cetera. But I just wanted to stress that point that you made. It is very important to have that one contact person.
And a lot of times, take a death case or even a serious injury case. They're not thinking to call their lawyer right away because they're calling the ambulance or they're trying to deal with that situation. So it's not uncommon as an attorney to not even know what happened until a day or two later. Because, for example, there's if they don't call the ambulance within a certain period of time, that's an OSHA violation. So it is a minefield.
And there are some very tight timelines that OSHA has mandated. For example, in the fatality realm, you are to report that to OSHA within 8 hours. So when you say, look, it's not the first thought to call your lawyer, well, it needs to be up there, or it needs to be up there to call OSHA, because 8 hours is incredibly short time frame. It's not next business day. So there are some very tight timelines here. So if someone would have a fatal accident at their workplace on, let's say, a Saturday night, you don't get to wait until Monday. You don't even get to wait until the next morning. If it happens at 10 o'clock on a Saturday night, by 6 a.m., it needs to be reported. It is a very tight time frame, one that, frankly, we don't see anywhere else that I'm aware of.
No, that's a good point. I can't think of any other aspect of the law where the timelines are that tight. And it brings up a whole lot of other questions. I mean, we're talking about a fatality, but let's say it's a matter of a serious injury that many people are injured. You're dealing with more than one issue at one time. So the reason why we're talking about this, I believe, is because the employers have to be educated ahead of time. Usually when you're calling your lawyer saying, what do I do? Well, things can't be undone. So it's important for HR and health safety officers, et cetera, to be educated, trained, so that the reaction is not a long thought out process, but it's just a matter of protocol.
Yeah. So let's, for our listeners, go through this, because there's fatalities, which is one category, which have to be reported within 8 hours. But then there's another category that needs to be reported to OSHA within 24 hours. And that's whenever there is an injury that results in an amputation, the loss of an eye, or the most common, an overnight hospitalization. So in other words, there's any injury of any kind that results in an overnight hospital stay, it must be reported to OSHA within 24 hours. And again, that's a very tight time frame, and it highlights the need to have a plan before an injury ever occurs. Now, there's one exception to that overnight hospitalization rule, and that is if the injury was caused by a car accident. And the reasoning behind that, as I understand it, is that, frankly, driving a car is a known potentially hazardous activity. And it's not something that was caused by the work environment, but it was caused by, driving on the highway or the road, et cetera, et cetera. So OSHA says, look, car accidents, that's a whole separate area. Our goal is to make sure that the workplace itself is safe, not driving on the road while you may be employed, but the workplace itself. So we exclude any car accident related injuries. But if it's at the workplace and it results in, as I said, amputation, loss of an eye, or overnight hospitalization, it has to be reported within 24 hours.
By the way, this is not to say that other laws may not apply. So this is not a workers' comp podcast, but if someone's driving while in the course of their employment, then workers' comp laws may apply. But you're right, Jeff, about OSHA. It doesn't apply. I do recall in the late 90s, maybe early 2000s, OSHA had a regulation saying that if you had an office in your home, that you had to comply with OSHA standards relating to that office. And the outcry came because everyone would have to make their home OSHA compliant. Everyone would have to install ramps. They would have to, have 36 inches or more of space between walls, and they couldn't have clutter. So that brings up the other issue.
You'd have to have a fire extinguisher.
Yes, exactly, which we should have anyway, of course.
Absolutely. But there are all kinds of things that OSHA requires that, as you said, in a home office, just are not realistic.
That's right. That's right.
So when we say that you need to report these things, such as fatalities or injuries that result in hospitalizations, I think it's important to kind of walk our listeners through what kind of things OSHA is looking for. In other words, what's that documentation? Because they have a rather standard reporting form on the OSHA website, which I think is actually one of the better government forms in that it really walks you through what it is they're looking for. But John, do you want to go through a couple of things that documentation is looking for?
Yeah, of course. By the way, I agree with your comment about the ease of the OSHA website and the forms and also the e-filing that you can do with these documents. But generally, if you have a fatality or the amputation, loss of an eye, overnight hospitalization, et cetera, there is a reporting requirement. So you would have to, as an employer, describe what occurred, importantly, the date and the time, describe the injury to the best of filer's knowledge as to what the injury is. And other issues may come up with how much information you have or how much information you're entitled to. But to the best of your knowledge, you have to describe what the injury was. Identify the underlying cause of the injury. This is one where I'm a little reluctant for an employer to make guesses, but some things are obvious. If fork truck overturned, that's obvious what happened. But some things aren't quite as obvious. So the employer should be a little more broad in answering that one. But, you can always tell what kind of equipment was being used, what chemical was being used, or whether there was a tripping hazard and the like.
Yeah, they're really trying to get you to, for lack of a better term, set the scene. What did things look like right before the accident? And then what caused the accident to the best of your knowledge? Because they're trying to determine essentially, is this an ongoing issue or was this a one time thing? I mean, I had an incident not too long ago where somebody brought their dog to work and their dog jumped on somebody and injured the person. The dog was not on a leash. They had to share that with OSHA because the person ended up staying in the hospital overnight. So they had to fill out this report. And it's very easy to say, you know what? Someone brought their dog to work, a dog jumped on somebody, and that led to this injury. In all honesty, OSHA is looking for, is this something that can happen again? Or, is this something that was honestly, an accident? Because if it is, the person tripped over something that we have that's permanently in the building, they're much more likely to look at those issues than they are, I'll say, a one time thing like, hey, somebody brought their dog to work and the dog got off of its leash and jumped on someone.
Well, that's a very good point, Jeff. I love the type of cases you get. uh, so we are also talking about, in this regard, we're talking about defenses that an employer may have. So let's say the employer has a rule that says you can't bring your dog into the office. I don't know who would have that, but let's suppose they do. And someone violates that rule, brings a dog into the office. Should the employer get dinged for the violation of the rule? Well, there we have an employee who's on a frolic, if you will. In other words, not following the rules. The employer may have a defense to that, but the employer still may get cited for failing to enforce the policy or prevent the violation of the policy as well.
Yeah, well, in this case, I'm happy to report that OSHA closed its case and no citation was issued. So, it was a good thing. Now, one of the other things is your responsibility is not done when you send your documentation into OSHA, because one of the things that you have to do is, as an employer, you need to post essentially your summary of this incident, what you submitted to OSHA. You need to post that at the location of the injury to warn other employees of a potential hazard. And that has to stay there for a period of time.
Yeah. And this is, at this time, you've had an opportunity to talk with counsel if it's necessary to make sure that you're posting accurate information, but that you're not waiving some other right you have to assert a defense. So I would involve counsel at this point unless you have a very experienced health safety officer. The posting requirement usually is not one that an employer relishes. I've had situations where the employer has timed the posting. In other words, timing when they entered into, for example, a settlement agreement, but time the posting when the least number of people were going to be there. But by and large, you have to post where they tell you to post. So you kind of have to just, suck it up and do the posting. You're going to have to do it at some point.
Absolutely. Now, we talked about the reporting and the posting requirement, but there are also records that need to be kept, even for injuries that don't trigger that reporting mechanism. I just want to make sure that our listeners are aware of those. So, not only, obviously, you need to keep it for any fatality, But any work-related injury or illness that results in a loss of consciousness or days away from work, you need to keep records of that. Any work-related injury or illness that requires medical treatment beyond first aid, again, you need to keep a record of that. And then the other category, and this is in the OSHA law itself, is that you have to keep a record of any work-related diagnosis of cancer, chronic irreversible diseases, fractured or cracked bones or teeth, and punctured eardrums. So there's a number of things that you need to keep a record on, even if it doesn't fall into, hey, these need to be reported immediately, so that if you are ever audited by OSHA, they can look at all of those records and it's not seen as you are ignoring potential hazards.
I got to tell you, I'd love to see who these people are that wrote all these specific things. Puncturing of eardrums, this is what we're looking out for. I mean, it boggles my mind that that's an issue. But regardless, you do have to keep records. The OSHA website we referred to offers an excellent portal in order to supply the records. Generally, they're due, I think, in April for the previous calendar year. You can get an extension, I think, up to the end of that calendar year. And the employer can be cited for that, failing to keep records. That's fairly rare. It's usually an add-on when OSHA is citing you for something else.
So following any kind of OSHA incident, we've mentioned a couple of times you can receive a citation, but the other area that you may have to deal with is that follow-up inspection from an OSHA field worker. And we're not going to cover that in this podcast. Frankly, our next podcast, we're going to talk about what to do when OSHA comes and knocking at your door. But as we wrap up today's podcast, I always like to give our listeners a couple of takeaways from here. So, John, do you have a good takeaway from our discussion here today for our listeners?
I mentioned this at the outset. OSHA is, it's certainly not our friend, but there's a lot of resources that OSHA provides. In fact, there are resources right here in Pennsylvania where you can get free training. And I would ask anyone that's interested to go to Indiana University of Pennsylvania has a program that is, I don't want to say sponsored by OSHA, but OSHA has an affiliation with it. You can get free training. OSHA's not going to go away, but the way you keep them away from your door is with training and education. That's my takeaway, to take advantage of educational opportunities, the training opportunities you have with OSHA. And by the way, if you do get a citation later on down the line, that's exhibit A for your defense. Say, hey, look, we're doing the best we can here. I did this training. We're being proactive with regard to the health and safety of our employees.
Absolutely. And I think my takeaway would be for everyone to know that OSHA's goal is to determine whether there is an ongoing hazard and to keep employees safe from inherently dangerous things. And when you know the agency goal, that helps you respond if there is any issue. And I think the other is something we mentioned during our show today, and that is have a plan before you have an issue. Have somebody who's designated as responsible for safety and to be the point person if you would have any issue, that is up to date on what OSHA requirements are. So with that, I want to thank all of our listeners for joining us here today on the Employment Law Counselor podcast, where we try and make sense of the world of labor and employment law. On behalf of myself and John Baker, we thank you for listening. Check back with us as we'll be dropping episodes regularly on a variety of different employment law topics. As I mentioned, our next topic will be what to do when OSHA comes knocking at your door and how to handle that. If you enjoyed this episode, please leave us a 5-star review, tell your friends, and subscribe to the podcast. For more information on this and many other topics, please visit our blog at www.theemploymentcounselor.com. Until next time, stay safe and stay compliant.